Today we want to talk a little bit about something called cancellation of removal. Most immigrants think that being put into deportation is the worst thing that could possibly happen. But sometimes being put into deportation can be a pathway to getting lawful permanent residency, or what we sometimes call a green card. In this video, we're going to talk about something called cancellation of removal. Cancellation of removal is a defense to being deported or removed from the United States. In fact, rather than being deported, you are giving lawful permanent residency. But only people in deportation before an immigration court or an immigration judge can ask for cancellation of removal. This is not something that you can start on your own. This is something you apply for and get from an immigration judge. So let's talk a little bit about the different requirements for cancellation of removal. First, you have to show that you have been in the United States for 10 years. This is called continuous physical presence. If you've left the United States in the past 10 years, you can still show this continuous physical presence if no single trip you took outside of the United States was more than 90 days long. And if all of your trips combined, if all of your trips counted all together, did not last more than 180 days. Now, the court is not going to help you to look for evidence of continuous physical presence. However, you can use anything that shows you have been here. You can learn more in our Proving Continuous Physical Residence requirements on our blog post. But please know, you stop accruing the 10 years needed as soon as you receive a notice that you have to go to court. It's called the notice to appear. You also stop accruing this 10 years that you will need as soon as you commit any kind of a crime that puts you into deportation. Now, there are a lot of things that you can show that you have been here for 10 years and that you have this 10 years of physical presence. Some of the really common things that people have and we'll look at are things like rent receipts, mortgage payment, a printout from the Register of Deeds with your children's birth certificates, marriage certificates, health records from a dentist or a physician. Perhaps you have a MyChart account with your primary care physician that can show that you've gone in for all of your checkups over the last 10 years. You can show that you filed your income taxes. You can show your children's school records, pay stubs, utility bills, cell phone bills. You can even use affidavits or sworn statements from friends and family. But those statements from your friends and family have to be very detailed, and they have to give concrete examples of your life in the United States. The second requirement for cancellation of removal is that you have to show you have something called good moral character. The law never really qualifies and says what specifically is good moral character. But it does tell you what will prevent you from showing you have good moral character. Good way to show that you have good moral character is through sworn statements from your family and friends who can vouch for you. What will stop you from being able to show good moral character are these things. First, if you are what immigration calls a habitual drunkard, you cannot show good moral character. Basically, if you have a drinking problem, if you drink too much alcohol, immigration can deny an application that requires good moral character. What they will do is look to see, for example, if you have drunk driving tickets. You also can't show good moral character if you have drug use or convictions for drug use. Certain criminal convictions for illegal gambling or earning most of your income through illegal gambling will stop you from being able to show that you have good moral character. Lying to immigration, for example, if you have a criminal conviction and you don't include it on an application, they will say that you lied to immigration and that you cannot show that you have good moral character. Even if the actual conviction would not have kept you from getting cancellation of removal, simply not disclosing it will mean that you can't show that you have good moral character. Usually, you must show that you have maintained good moral character during a certain time frame within the Immigration and Nationality Act. However, immigration can look at anything as far back as they want to. But for cancellation of removal, you have to show that you have good moral character for the 10 years that you need to show your physical presence. So at any time in your personal history, if immigration wants to look at anything you've done during that 10 years, or at any time before that 10 years, they can look at it. You will want to show, if you have any criminal history, that you have something called rehabilitation, and you want to start on that right away. So if, for example, you have tickets for drunk driving, you're going to want to show that you went into counseling, that you had alcohol assessment, that you've stopped drinking, that you've seen a therapist, that you've kept all of your appointments, and that you're no longer a danger to people because that you drink. Third, to qualify for cancellation or removal, you must show that your deportation would cause extreme and unusual hardship to at least one eligible family member. An eligible family member for this can be a child who is under the age of 21 and unmarried, and that child must be also either a lawful permanent resident of the United States or a United States citizen. Another relative could be a parent who is either a lawful permanent resident or a United States citizen. And finally, that relative could be a husband or a wife, a spouse who is either a lawful permanent resident of the United States or a United States citizen. Immigration courts want to see extreme and unusual hardship that is more than we would just see as typical hardship with someone's being deported. Your family member cannot just show that they're going to struggle after you're deported, but they must show extreme and unusual hardship. For example, one court ruled that losing your home and all of your family ties is not considered extreme or unusual hardship because everyone who's deported is going to lose their home and all of their family ties. Don't take this lightly. Look for any and all evidence that shows that your family member would suffer extreme and unusual hardship. Acceptable forms of extreme and unusual hardship will vary depending on your family member and which family member would suffer if you were deported. But it's really important to start working with a good immigration attorney as soon as possible. You can ask for recommendations on our website. We have a list of good immigration attorneys. If you're not in our area, the American Immigration Lawyers Association also has a link on their website. You can find an immigration attorney who belongs to the National Association for most immigration attorneys. You'll want to ask some questions before you start. You want to know if they take a payment plan. You'll want to know if you're going to work with the attorney or a paralegal. You want to know if the quoted price includes any appeals. It's really important to establish a good relationship with your attorney right from the beginning.